Hey, everybody. Wendy Sellers here, the HR lady. I am here with my co-host, JC.
Yes, you are. How are you doing, Wendy?
Yes, I am doing fantastic. You know what? Can't complain because no one's listening. Ha, ha, ha.
Wendy, a lot of people are listening, and they're listening all over the world. They love this podcast. We got a heavy one to get into today, don't we?
Yeah, I want to talk about non-competes. Nobody throw anything at me, okay? Well, you can because it'll just go to your own car, your own radio. But non-competes, hot, hot, hot topic.
I've got some news as of 1 hour ago. You ready?
Yep.
Now, by the time people hear this, it might not be 1 hour old to you, and there could be something new that happens between now and the time that you hear this. But this will still be relevant. Earlier this year, the U.S. Federal Trade Commission, the FTC, issued a regulation that effectively bans most non-compete agreements for employees and independent contractors, with an effective date of September 4th, 2024. Litigation challenging the FTC's authority to enforce this rule is ongoing, but no court has yet invalidated it, leaving the rule on track to take effect. There are rumors there's a court in Florida that might be on track to challenge. I'm not even going to lie, Wendy might have an update on that coming up momentarily. But look, the rule prohibits entering new non-competes after the effective date and renders existing non-competes unenforceable, except for a narrowly defined group of senior executives. Employers must notify affected workers by September 4th that their non-compete agreements are no longer enforceable. Although the rule does not mandate formal rescission of non-competes, failure to send notices could lead to FTC enforcement actions. Employers are strongly encouraged to, quote, immediately inventory all relevant agreements and consult legal counsel, end quote, to prepare for end times and distribute required notices in compliance with the rule. Wendy, back to you.
It's insane, man. It is so insane. So I'm in Florida, for those of you that don't know. Texas has already said, nope, this isn't right. Florida just said, nope, this isn't right. But we're still waiting. Like, what does that mean? Pennsylvania, on the other hand, actually passed a law banning all non-compete agreements for medical professionals effective January 1st, 2025. So it's interesting that all these states are doing, something different. Everybody's doing something different. My biggest thing that I wanted to bring this up, to our listeners is there's a lot of people this covers, right? It says the FTC website itself says roughly 1 in 5 Americans or 30 million people are subject to non-competes. That is a lot of people that may no longer have to be dealing with non-competes or have to just sit there and go, I don't know what my particular state's going to do. What do you got, JC?
Yeah, breaking news. Actually, it won't be breaking by the time you hear this as the listener, but for us it is. A federal court in Florida issued a preliminary injunction against the FTC's non-compete rule, but it only applies to the named plaintiff in the case. This is the second such limited injunction following a similar ruling, as Wendy mentioned, in Texas. The Florida court focused on the major questions doctrine, questioning the FTC's authority to issue such a significant rule. The outcome of these cases leaves the FTC's rules future uncertain, with a final decision expected from Texas by August 30th. Back to you.
Yeah, the August 30th is the magical number magical date that we're all waiting for. The one in Florida, it was the properties of the villages. A shocker. If you know anything about the villages, of course, they fight everything that will help somebody else. I used to live right by them, and I was like, this is a really cool place to hang out and shop. And then I found out who they really were. And I said, nah, not going to do that anymore. Anyway, sidebar there. Listen, if you have non-competes with your employees and you're saying, I don't know what to do, unfortunately, I can't give you a full answer because we're going to have to readdress this after August 30th to see what the federal court systems are going to do. But, let's put that all aside right now. My question, JC, is why would an employer even want a non-compete? What's your opinion?
I can answer that. I could answer that right away.
Sure.
And I'm going to do it from the broadcast industry perspective. You definitely want that non-compete clause at play and in place for the people that are your on-air talent. You don't want them jumping from one brand immediately over to another. You might have built within the non-compete something as simple as, the talent would not be able to immediately go to another station, but they might need a 3 to 6 month cooling off period built within that contract. There's one example from the twisted world that I have a background in over to you from your perspective.
Yeah. So obviously I'm the HR lady. My perspective is that a few things, it's hard to attract people. It's harder to retain them. And some employees just won't even come to your organization as a candidate if they have heard somewhere or they actually know that there's going to be a non-compete that they have to sign. Gone are the days, unfortunately, where employers hire people for the long term, right? That we all say, yeah, we're going to. But recessions happens, layoffs, this, that, and the other. If you have shareholders who want more of their share of money than anyone else, they're going to possibly say, no, we're going to get the best people in the recruiting process, but then we want them here long term. So we'll scare them of not jumping ship into having a non-compete. So number one, listeners, if that is you, I'm totally cool with that. I get it. I understand your approach, but please make sure you get a lawyer involved. I worked with a company once before where I was the HR director, and it was a very short period of time. It actually was what prompted me to go into consulting, because these people use non-competes on every single employee, and that is not legal. You can't have these non-competes on, somebody who they don't have any knowledge in their head. It's all about retaining the knowledge and the trade secrets and things like that. But that's also where you can get a non-solicitation agreement versus a non-compete. So whether this non-compete stuff stays or the courts throw it out and they say, do whatever you want, or they say, okay, every state, you could ban them. One thing that you might want to consider is a non-solicitation agreement. And that means if an employee leaves your company voluntarily or not, that they can't steal your customers. They can't solicit your customers. And you may even have that they can't solicit your current employees, so they take them to the new company. So I really do believe that most companies, that's really what they need, is the non-solicitation agreement, not even the confidentiality agreement. That's something else completely. But I think a lot of employers confuse the two. So they just throw everything at the new hires and say, sign everything, when they're probably losing some good candidates that don't even want to interview because of the non-compete.
Employment non-compete agreement prevents the employee from working for a competitor or starting a competing business for a specified period after leaving the company. A sale of business non-compete restricts the seller of a business from starting or joining a competing business within a certain geographic area and time frame. There's also the partnership agreement non-compete that prevents partners from competing with partnership business during and after the partnership's term. All of these have the potential to be affected. These types of non-compete agreements would potentially fall under that FTC proposed rule, which aims to ban most non-compete clauses in employment contracts. It would be all-encompassing of everything there previously mentioned. That included, I want to highlight it again, sale of business non-compete. That's a biggie. Back to you.
Yeah, it absolutely is. And if the non-compete ban stays on the federal level, or just say on your state level even, currently, the FTC is proposing that you could still have one for a senior executive, but you do need to understand what they mean by senior executive. So check that out on the FTC's website, or you can go to my website and my blog, thehrlady.com, and look for my blog. And I have an article on there that I keep updating every 3 days because more information keeps coming out. But if senior executive isn't just because of their title, they have to be like in a policy-making decision and make X amount of money, which is currently $151,000 or more. So it is a mess. It's a hot mess. Nobody knows what to do. Some companies said, okay, we're just going to follow the FTC guide, and already notified their employees that, okay, your non-competes are gone. And if you already did that, you can't take it back. So, your employees are only going to sign a non-compete if you give them something, usually more money. That's why we usually do it when it's a new hire, like, here, in exchange for this offer, you're going to sign this. Well, you have to give them something to make it worth it. So if it does stay, though, the FTC ban, the federal ban, there is an actual guide provided by the FTC on their website, and there's a Word document you could download, which has the model notice wording, so that you can just adjust it for your company and then notify all your employees that the non-compete is gone. if you're like most people that I know, most companies that I know, everybody's waiting around till August 30th to find out, because currently the FTC's new, their rule to say non-competes are unenforceable, you have to notify your workers by September 4th. So I would say October 30th, September 1st, September 3rd, maybe September 4th is when people are going to notify their workers, or maybe we're not if it all gets thrown out. But it is just, it's a crazy, crazy tool.
You got me thinking for a second, Wendy. Imagine how many businesses in this short time frame are going to let all the workers go, turn them all into independent contractors, retain their senior executives that have that access to sensitive strategic information and significant influence on company ops, focus the business just on that core C-suite, and everyone's an independent contractor from there. And then they're going to have a whole nother ball of hassle if they do something like that. I don't know. My mind went down a rabbit hole on that,
No, I think you're right. I think companies are going to be scrambling, just saying, let's figure out another way. And listen, folks, don't do that. Okay. What he just said, please don't do that, because it's probably illegal. It could be legal in some cases, but it's most likely illegal. If they were employees today, what did you change in their function and everything else to make them a 1099 tomorrow? That's a whole other conversation for sure. So it's definitely, it is scary. 30 million people this would affect. And, it's only 1 in 5 Americans, but that's a lot of people that can be off the hook and walk out your door because they no longer have a non-compete. So what are you going to do? So let's just pretend for a hot second here that this goes through and it stays and says September 5th, all non-competes are banned. My thoughts and my suggestions are, if you've listened to any of my podcasts before, is to get your act together in your recruiting, get your act together with your managers, train your managers how to manage, how to have conversations, how to use this thing called empathy with your employees. Don't roll over and play dead. Don't let your employees walk all over you, but definitely make sure that you have competent managers that can handle conversations about the non-compete, but then also handling conversations to say, please don't leave us, and this is the reason why. We're a great company. We have a great company culture. We have good benefits. We have great pay. So even without the non-compete, they wouldn't want to leave. Wouldn't that be ideal?
Yeah, it would be ideal. And just to pin in again, back on the legal counsel side of things, again, I'm not a lawyer, neither is Wendy, as you know. She could play one on TV, though. She looks that good. But jokes aside, there could be situations where rehiring might be necessary, believe it or not. And I may stand corrected here and definitely, seek legal guidance on this. But if you are restructuring a role to comply with the new regulations under a FTC proposed rule, so if the company needs to redefine the job duties or employment terms significantly, you might opt to terminate the current employment and offer a new contract without the non-complete clause built in. But that approach is very complex, and I really do recommend doing that with legal guidance to avoid any potential legal risks or violations. I know there's a lot of small businesses out there that might be listening that could be thinking about all these differences. It's good to get the information, be well read, and then it puts you in a better position when you're talking with your legal counsel and seeking legal guidance. Just having these scenarios and thinking about the options, because we know that you're working hard already. So just trying to help you out a little bit. Wendy, back to you.
Yeah, absolutely. Thank you for that. A lawyer is going to be incredibly important to have. And I would say a lawyer in your state or states that you operate in, that you have employees in, because as we can see, Pennsylvania has one law, Texas is fighting another one. Florida is fighting it as well, but they're all very specific to the companies who file those lawsuits. So the next couple of weeks is definitely going to be interesting to see what happens here. Make sure that you do have a competent HR person or hire an HR consultant, as well as getting the attorney. An HR consultant is probably going to be a little cheaper than an attorney, but we don't know everything. And even though I was on a actual webinar the other day that there was all these lawyers on there, I was a guest. And they were saying this is new to all of us. So please, nobody send out any notices unless you absolutely already decided, we're just doing away with them anyways, because it never made sense to begin with.
Yeah, and that's not a cheap plug. The HR consultant, if you're not aware, they can assist with tasks like, and Wendy, jump in, please correct me, restructuring, policy development, talent management, navigating legal challenges like that FTC proposed rule on non-competes. They bring an external consultant perspective to the table, and you could gain objective perspectives and access on not just up-to-date knowledge, helping streamline your HR processes, but they could also take a look at overall improvement of your organizational effectiveness from a different perspective at the same time. Am I wrong?
Right.
Okay.
No, 100%. I mean, that's what my clients do to call me. I had like a emergency situation today with the client who they actually do what I tell them to do. And so they don't have to pay me that much anymore because they're not losing people. But there was a specific FMLA issue and they would have never known, how to deal with it. Even their HR person didn't know how to deal with it because it was just a very, very specific situation. It was very closely related to ADA. Anyways, what can you do instead of having non-competes if you decide, it's not worth hiring a consultant, hiring a lawyer, getting people to turn down our offer? Be nice. Hire the right person for the right reasons. Give them feedback. Train managers, train staff, hold people accountable, but be nice. And then above all, pay them what they are worth. And then they probably won't walk out the door if you do all of those things. I can't guarantee that. One other thing I want to say before we wrap up is, make sure that you are either following a lawyer online, an HR consultant like myself online, whether it's on LinkedIn, whether you're hooked up to their newsletter or their blog, because as soon as this information for non-competes comes up, I assure you, we're all going to be releasing more information. And then if you are a small business owner listening to this, a manager, an HR professional, you do know how crucial effective HR management is for your business. And it is very, very overwhelming. I have just rolled out a new program. It's called the Insider Access Membership Program. And so if you want to check it out, that you can get a 7-day free trial. Yes, free, simply by going to thehrlady.net, NET, and you can get on-demand courses, forums, policies, live trainings with me, recorded trainings, and so much more. So check that out. Otherwise, we hope this information has been helpful. Thanks for joining us and take care.